It's just so kind of a barrier.
Yeah, of course.
Let's see if we've got a lapel mic. Yeah.
That's her perspective.
Let's see if I can get this on. What?
Actually, I'm going to be right back.
Hi, I'm Julia.
Joy John Whealan.
I'm not a lawyer. I got drummed out because I got acquired carpal tunnel into the right, but I'm hoping to go back. In New York, I'm hoping.
Can you?
My brother's a lawyer here. He runs the Media Access Project. Andy Schwartzman.
I've heard of the Media Access Project. So I would think you could be a lawyer with.
Well, I acquired this. It's different when you acquire something and you're in school where there's somebody that I'm sure you're supposed to. And as a matter of fact, the former head of this I think everybody's kind of when I was applying to law school, I wanted to bring that up.
Go ahead.
Thank you for coming.
Oh, thank you.
Hello?
Hello? Yeah. All right. I'll just hold this and then give it to you since I'll be quick. Hello, everyone. My name is Beth Colby. For those of you I haven't met, I'm president of NALSWD. We're so excited to have all of you here. We're excited for a full day of fantastic speakers. You'll be hearing from me throughout the day, so please introduce yourself if I haven't met you yet. One quick note, if you're using CART, they'll be switching off every 30 minutes, so the screen will go blank for about 2 seconds, but then it'll pick back up. And if there's any questions, please do let me know throughout the conference. We're very excited to be here at GW Law School. We're going to have the welcome speech, as you see in your program, by John Whealan, who's one of the deans here at GW Law School. And he teaches intellectual property, and I'll let him take it away.
Well, thank you very much, Beth, and thank you, everybody, for inviting me to speak. Is Andra Charnak in the room? There she is. Andra's one of our Associate Deans of Students who invited me to present today. She assists our students with special needs, and she popped in my office a couple weeks ago, and our dean could not be here, and she thought of me, and I think you'll see why in a few minutes, and I wanted to thank her for asking me to do it. I wanted to welcome you on behalf of our dean, Paul Berman. He couldn't be here. I was just out with him in California, and he's off to Salt Lake, Utah, I think, trying to get students like you to come to our school. But I was able to come back and be with you. And I've read about your organization, and it was very impressive to see such a good turnout and such a large organization in just 5 years. It's really quite impressive. And I thought what I'd do is talk to you a little bit about GW just for a few minutes, as deans do, and then tell you a little bit about my story, and I think you'll see some connections. So GW is, I think, the oldest law school in D.C. We've been around for over 100 years, and it's a really fun place to work. I've only been here about 4 years now, and I spent the first 15 or so years of my career in the federal government doing mostly intellectual property and mostly patent law. And I had taught, but came to GW a couple years ago as their associate dean for intellectual property law. And GW is a large, top 20 law school in the country, national, international reach, and we're very proud of it. It was, I think, historically more of a part-time program that played to people that were working in D.C., working in the evening and coming to school during the day. But it's really kind of flipped and become now a mainstay day program, top 20 school, and still appreciates and has a part-time program for people that want to do it in 4 years instead of 3 years, or might be working. It's funny, your generation, we used to say 6 o'clock were evening classes, but I'm learning from your generation 6 o'clock could be midday. And we even have some students who are in our evening program who are just regular students. So the school has really evolved, and as you've seen, it's grown from one building, and we're wrapping around the quad, and maybe we'll take over the next building. And we have about 1,500 students, most days, most full-time students, but some part-time students. We also have an international and a national LLM program where people come for specialized areas, which I'll talk about in a minute, during the year, and they're in class with all the other students. So GW is not just a big school. They have certain specialty areas that we hope that we're pretty good at and we focus on. And one is intellectual property. We've had one of the largest and oldest intellectual property programs in the United States. I think our graduates have helped patent the plane and the telephone and a lot of the older patents. I guess they're probably off patent now. Now it's much more important to patent the smartphone and the iPad. But we actually do have people that are working in those areas as well. It's kind of interesting how the technology moves. But we also have areas of specialty, international law. We have a big international program. We have a government contracts program, which is, I think, second to none in the United States. Not surprisingly, given government contracts probably goes on in D.C., probably more than any place else. And we have expert areas in our finance areas and some other areas as well. And what the school tries to do, I think, is really take advantage of being in D.C. The federal government is here, and it's not many other places of this scope. And because of the policy that's done here, the nonprofit or the government sector work that's done here, I think the school really partners up with those groups. We have faculty members who are working in the government. We have students that intern with these government agencies, and then there's a back and forth. We have alumni that go work for the government, and I think we really take advantage of Washington, D.C. And I think, to the extent my knowledge about your organization and these issues is somewhat anecdotal, from my own personal experience. I don't claim to be an expert in disability law. But Washington, D.C. Seems to be a good place, or among the good places to consider working. It's a fairly accessible city compared to some, I would think. And I think the federal government is a fairly progressive employer, or at least hopefully they are. And if it is a good city for those two reasons, you might want to consider this place for employment. I can tell you it's a great city to live in. I don't drive a car, I've lived in major cities my life, and people think I'm just a Northeast person, and it's like I have to live a place where there's a metro, and D.C. probably has one of the better metro systems, public transportation systems in the country. And it's just I think it's just a good place for these types of issues and these types of stuff. So that's enough about GW. If anybody's ever interested, you're all in school. I'm not trying to recruit you. Don't get me wrong. But some people will come for our LLM programs and stuff. And I think it's helpful to show what the school is interested in for us to be honored to host you. As our current dean likes to say, he calls it law in action. He says, we're not just an ivory towered school. I guess we're red brick. And the school is interested in not just studying law, not just writing about law, but actually doing it. And our professors are fairly active in it. During one 6-week period in the fall, we had 6 or 8 professors who testified on Capitol Hill about different issues. The case, I don't know if you know the case in the spring, the GPS case that the Supreme Court took, whether they can put a GPS on your car without telling you, without a warrant. Well, Oren Kerr and Dan Solov are 2 of our experts in privacy law and computer law, and Oren's work was cited by all 3 opinions. There were 3 opinions in the case, and I was coming home one night, and they were talking about the case on NPR, and I was like, well, I wonder if Oren's involved in this case, and all of a sudden he comes on the radio, and so it's kind of cool when you hear your professors talking in real time. I think the days of influence the law by writing law review articles and teaching alone are over. I think it's much more interesting to do that and to be involved in it on a real-time basis where cases are being litigated, where Congress is making changes, and that's what the school does. I think it does it helps its students be introduced to that, and I think the faculty is very interested in that as well. And it's just more fun. I mean, the law's going on right outside, and why not participate? And I try to do that in the area of patent law as well, both nationally and internationally. But I think your organization is a perfect example of that. 5 years ago, you guys didn't exist, right? What happened? A bunch of people were sitting around one night drinking a beer and said, we ought to get together and form an organization. You did. You did. Look what you've done. And I think it's a great example of how the whole can be greater than the sum of its parts, especially for your type of an organization, to bring awareness to these issues, to bring a collective to these issues, and to publicize these issues to universities and law schools, and to make people aware and try to help solve some of the problems or propose problems to be solved. I think you're a perfect example of law in action because you've taken an issue, and you're a bunch of lawyers, or you're going to be a bunch of lawyers, and you're taking it to the next step. And I think it's very interesting how your group has kind of merged both the issues that law students are dealing with as well as the area of law and what the consequences of that area of law is. And, I hope law schools want to comply with the law. I know we do. Sometimes you just need to be educated about it. I assume we probably have faculty members who are experts in this area. But not every professor will be, or not every administrator will be, and they want to learn and they want to be brought to their attention. And that's why I think an organization like yourself that is really grassroots and been built by a small group of people is quite impressive. So we would be happy to host in the future and participate in or cooperate with you, because I think it's a very good organization. So the other reason Andra asked me to speak was not only was I willing to come on a Saturday morning to come in after flying back from California. But for those of you that haven't figured it out, I have albinism and am legally blind. And I guess it's a little harder to know now when I get older and I'm starting to look closer to my peers, or I guess maybe my peers are looking more like me. But I've had this color hair and this color pigmentation since I was born, and I'm about 48 now, and I thought I'd tell you a little bit about what my experience was anecdotally, to the extent it's relevant at all to any of yours. So, I was born with albinism. I have 4 brothers and sisters, and none of them have it, and it's a 1 in 4 shot, I guess, and I think at the time they couldn't even test for it. And my eyesight wasn't very good, so I'm legally blind. I'm about 2,300 non-correctable, or these correct a little bit, but not a lot. And so I grew up looking different than a lot of my friends, and also basically not being able to see a blackboard, and not being able to drive, although at 5 you can't drive anyway. And so I had to deal with that. And, the knowledge of the issues wasn't as great then, and I went to schools, regular schools like everybody else, and you couldn't see a blackboard. And so you kind of have 2 choices. You either don't see it, and you're probably not going to do so well, or you have to figure out a way to see it. And, you'd be sitting here as a first row seat, and I couldn't see it. or I couldn't see it well enough, and I'd have to go talk to a teacher and say, you know, look, we got to work something out, and I'd sit next to the teacher. Now, there's stigma in doing that, but my point of this story is there's a kind of a certain tension between you having an issue you got to deal with, at least I was a little bit embarrassed by it, and you having to advocate on your behalf with nice people, don't get me wrong, to accomplish what you need to accomplish to be able to at least break even as best you can. And I have parents, and you know they advocated as well, but it wasn't like this aggressive type of advocacy. It was just you're just trying to see a blackboard. It's not that easy to do when you can't see well, and you have to figure it out. And there wasn't all this equipment or these tools or things like that, so you really just had to interact with people and tell them what the issue was and move from there. And so I was in a system where it worked pretty well based on relationships. You know, I had brothers who were brother and sister who were older than me, and you know, you go to a school where it's not such a huge place, and they know who you are at least, and they try to accommodate. And I went to a high school, and again, still had the same issues. It gets harder in high school because classes get bigger, and but you know, I would stand to the side of the room or try to figure out a way to do it. And in addition, you know, you worked with friends or you tried to deal with it as best you could. About when I was 17 or 18 years old, I went, somebody suggested I go talk to some people at the lighthouse, which I didn't think I really needed to do because I didn't think I was blind. I thought I could see. But they said, go talk to some people there, and I did, and then I went to see a doctor who was what's called a low vision specialist. So I expect a few of you in the room probably know who this is, since some people may have visual impairments as well. But I said, I don't need to go see a low vision specialist. I already have a doctor. And they said, well, you got to go, or we're not going to even talk to you. And I said, okay, I'll go. So I went to this guy in New York, and I remember the appointment where I was looking at the eye chart, and I could always read the E, the F, and the P, and that was it. And they thought I was always kidding, and I wasn't. And then he put these glasses on me, and I was like, wow, I could read the whole eye chart. And he put what were these telescopes that you now see on ER or whatever it is. I guess ER is an old show now, but so you can see, you know, they mount these ugly black things on top of black glasses, and you can see. So I remember that day when I could now read the whole eye chart. I mean, I could read the Made in Japan sign on the bottom of the eye chart. And he would have me guess at letters because you can see more than you actually think you can see. He's a really good, he still practices, and I've been in contact with him recently. So I go, he shows me what the glasses look like, and I'm like, oh my God, they're pretty ugly. And I didn't want to wear them. And he gives me a monocular and says, okay, go try this. He didn't even try to convince me to wear them. This guy was a pretty smart guy. And I used the monocular for a day or so, and you have to lift it up, and it's lousy. It's not going to help you really see. And so I told him to make the glasses. And then I used them in college, I'm sorry. And again, I was kind of sensitive to using them because they look ugly. They're not very attractive. And, you know, so there's this barrier between you wanting to get to where you need to go to, but now you have to be different to do it. And I don't know. I never really thought about it until I was sitting here thinking about this presentation. But you are these are the two things you're dealing with a lot. At least I was dealing with a lot. And at the end of the day, the reason I tell you this is I think all of that I had to do to get to where I was, I started to learn how to talk to people. I started to learn how to advocate. I started to learn how to speak on my own behalf. And then when I found out I could go to law school as a scientist, which wasn't quite so common at the time, I was like, oh, I could be pretty good at this. And I've now moved on, and I now have worked for judges, and I've now worked for the federal government, and I'm now an associate dean of a law school. And so just to give you an example, when I argue cases, people always said when I was arguing cases, well, you never look at your notes. And I'm like, well, yeah, I really can't because I can't read them. And so you had to develop a certain skill set of how to, be able to argue without looking down constantly. And looking down constantly, for those of you that can see, is not a good thing to do when you're arguing because you really lose contact with the judge or interaction. And so you basically take what you're not so good at, and it kind of spurs you, and it kind of builds on top of it, and I think it allows you to do some things that you probably wouldn't be able to do. And having white hair was not a lot of fun when I was a little kid. You know, people would yell things at me or call me names. Nobody does that anymore. People ask me why I have a ponytail. I say, well, because I can. And I also, at this age at least, and I also, you know, nobody is going to give me a hard time. And in some ways, people will remember who I am. If I walk into a room and I argue a case, people will remember, you know, there's not that many people walking around that do what I do that look like this. So what I've tried to do almost by accident is take what I could not do well, build on it, and use it to my advantage to the extent I can. And I've been very fortunate. So now I have a 14-year-old daughter. She doesn't have albinism, which is not surprising. It's rare that my wife didn't have the gene, and nobody thought she would. But about 5 years ago, she gave me a book on albino animals. And it was all these different animals that had albinism. And she thought it was kind of cool. And she thought it was kind of cool I had this. And she's actually now doing a paper on a genetic disorder, and she's doing it on this. And she was explaining to me the other day, she said, you know, you could have had it a lot worse. There's a lot of other issues and stuff like this. So it's become much more mainstream, and I look at her school and the way I think students hopefully now seem to accept differences a lot more, at least from what I've seen for her school and her generation, that everybody's kind of different. People are from mixed marriages, people are small, people are big. She has a student in her class who had leukemia. They all rallied around this kid, raised a lot of money. Some professor, one of their teachers said, well, I'll shave my head if you guys raised $5,000. They raised, of course, you give kids a goal like that, they raised like $7,000 and sat in a gym and they shaved the guy's head. And it's amazing how you can spin it and turn it around. So she asked me the other day, she said, you know, the $64,000 question, if you had it to do all over again and you didn't have albinism, you could see, would you do it? And I said, I don't know. You know, if you asked me that at 10, I would have said, yeah, sure. But I don't think I would have done what I've done or do what I do or be who I would be without some of these issues. And so from my personal experience, you know, I think I always say there are things that you are good at and there are things that you're not good at. Michael Jordan, no matter how hard I tried to play basketball, I wouldn't be as good as him, and he was great, or sports, or Tiger Woods, or whoever it is, and they know what they're good at, and I think you take what you're good at and you really be really good at it if you can, and you take what you're not so good at and you try to at least neutralize it if you can, or use it to your advantage if you can. And I think that's what I've tried to do, and I've had a good career and a good life, and hopefully I will continue to do it. And I would encourage all of you, it's very impressive just to see the size of the group and how you've collected yourselves, and I think can be very powerful, both as a teacher and as an advocate for students like yourselves. I'll speak just as a professor to end and say, look, when Andra will come to me, we had a woman in our class who had a hearing impairment, and you know, she came to us, she explained it. We did everything we could to accommodate. And I think that's what most professors, at least most of my colleagues here, would want to do. They need to know. They need to know what to do. And I think mostly that's what people will want to do to the extent they can. I think, you know, historically, how did people find out about this? You had to go talk to somebody. You had to have enough guts to go find who to talk to, and there wasn't somewhat of an organized system. And I think that's what you're doing. And I think it's great to have the organization from the students' end as well as from the school's end, because I think it must facilitate this type of communication and kind of make some sort of standards where they will exist. Obviously, every single student is different, but where we can learn from this, I think we'd like to. So I commend you. I hope you have a nice 2 days while you're here, and if I can be of more help or in the future, or if the GW can, please just call us. Thank you very much.
Thank you so much. And we have, for all of our speakers today, a little box of local chocolates from DC. So I hope you enjoy it.
So how do you say the acronym for your organization?
NALSWD. NALSWD, National Association of Law Students with Disabilities.
NALSLib?
NALSWD.
NALSWD.
NALSWD, yep.
You need a trademark?
It's not trademarked yet, but maybe we'll let you know if we need a trademark lawyer.
So you're moving in the right direction.
Yeah.
You're going to have T-shirts and branding.
Yeah. Well, we do have a logo now, but thank you so much. All right, well, we'll get started with our first panel. Jason Turkish will be the moderator.
Well, good morning, everybody. Let me just briefly introduce myself. My name is Jason Turkish. I'm a 3L at Northwestern, and I'm really proud and honored to be here today. I want to thank the Executive Board and Beth for inviting me to do this. I first came to a NALSWD conference 5 years ago as an undergrad, and it's really rewarding to witness how this group has evolved, and it's a pleasure to be here. I'm this morning going to moderate a discussion with three wonderful experts on difficulties and barriers to entering the legal profession, which I know is something we all experience and live every day, and is an important topic to us. The three broad subject areas that we're going to divide our time are issues related to the LSAT, because even though we all in this room are past it as an advocacy issue, I think it's something we all care about. Also, we're going to talk about disclosure issues when seeking employment, how to disclose to an employer, when to disclose, what to do if disclosing your disability creates conflict, how to approach that situation. And then also something we'll all be focused on very soon is the bar exam and how to apply for accommodations and how to advocate for yourself and what the state of the law is, the NCB case recently, and so forth. So what I think I'm going to do is, to save time, is just let our panelists just say a few words about themselves and introduce themselves. If we want to start with Paula at the end. And,
Good morning. So let's see. Is this on?
Yes.
Oh, good, because I can't hear it from here. But, my name is Paula Pearlman. I'm the Executive Director of the Disability Rights Legal Center. So how many of you are 1Ls? Can you just do a show of hands or clap? So about a little, like 8 or 9 of you, and 2Ls. You are 2Ls, like 1, 5, 2Ls, 3Ls. Vast majority. You guys want to hear about the bar exam? Yeah. Okay. And there's how many people are in the room more or less today, guys? You worked at the registration table.
It's about 35.
35. It feels fuller. It
we'll hope to grow as the morning goes on.
Yeah.
It's a Saturday.
Yeah, so I think it feels, so I guess I like to know who, and the rest of you in the room are speakers or other people who are not law students?
Correct.
Yes, correct?
A couple of administrators.
Oh, and law. Oh, good. Okay, so I run a nonprofit disability rights legal center in Los Angeles, California. The scope of our work is national. One of our programs is a cancer legal resource center. And we have offices in Los Angeles, in the Inland Empire area at the University of Laverne College of Law, Chicago, and in Coachella. So you could like crash on our floor there, you know, during the music festival. But there's lots of crickets in that office for some reason, because it's in the middle of the desert. And it's an incredibly underserved community. Before we were doing cases there were very limited resources. So right now we have a case against a school district for not having an emergency preparedness plan in place. So this little kid who used a wheelchair, and every other kid in his class who uses a wheelchair, when there's a fire drill, they go to a place and they're trapped, essentially. And so you get to burn the little kids with disabilities, but everybody else gets to get out safely. So that shouldn't take a lawsuit, should it? Oh, it shouldn't, but it does. So we use education, advocacy, and litigation to change the world. You look at me and you don't know that my mom was an immigrant. She has since died. She's a Holocaust survivor. You don't know that my dad used to beat that crap out of us growing up, so that I have, grew up with lots of violence and abuse, and somebody not being able to stop that. So my brief remarks are that you can't judge a book by its cover. You don't know who's on the other side of you as a new employer or opposing counsel. They don't know what's on the other side of them either. So I want to encourage us to be open-minded, not make assumptions, and continue to advocate staunchly. My life changed when my dad went to hit my little sister, who was 4 years old, and I was about 12. And I stood between him and my little sister and said, don't hit her. If you want to hit somebody, hit me, but don't hit her. And that, wow, that changes your life, where you realize you really are an advocate. And if I can't stand up to my dad to prevent him from hitting, if I can stand up to my dad to prevent him from hitting my little sister, I can stand up to anyone. And so can you. So that's the thing. You can do it too. Karla.
Okay, that's a tough act to follow. Okay, I assume you guys can hear me. It's a pretty small room. So my name is Carla Gilbride, and I came to disability law through, somewhat through my own personal experience. I'm totally blind and have been since birth. So, was always personally interested in these issues. And I went to law school here in DC at Georgetown. And then I was fortunate enough to get a clerkship for a year, so I did that in Seattle. And then I went to Disability Rights Advocates, where I worked with a great team of lawyers on a number of issues. I worked on some emergency preparedness cases, like Paula was talking about, and I worked on a lot of testing cases with Dan and others mostly involving the National Conference of Bar Examiners, so bar exam cases, but I also did some work around the LSAT as well, so I can talk more about that. And then about 8 months ago, I came back to the East Coast, and I've been here in DC working at a firm called Mehri and Skalet, which is a 10-lawyer firm that does a broad range of public interest type law. We do employee discrimination class actions under Title VII and other statutes. We do Fair Housing Act cases, including some design and construction cases, so new construction that's built without accessible units as a violation of Fair Housing Act, and also some consumer protection cases. So working on a range of stuff right now, and it's very exciting. So that's my story.
Good morning, everybody. My name is Dan Goldstein. I see a couple of familiar faces here, which is always reassuring. I've been doing disability rights litigation for 26 years now, since I was hired by the National Federation of the Blind to do some litigation. When I was first hired to do it, I knew absolutely nothing about disability rights, and the NFB very wisely paid me to sit and read for 2 days before they would even talk to me, so that I would, after reading, understand better than I had, which was certainly the case. If I had any views at all, it probably was sort of a Jerry's Kids view of disability, so a couple days spent reading Jacobus Tenbrook's articles and the like set me straight pretty quickly, and I've been having fun with this ever since. I am one of the partners in a small firm in Baltimore called Brown, Goldstein, and Levy. We do a number of other kinds of civil rights work besides disability rights work, but that's been where I've done most of my work. I should mention, for those of you who are not aware of it, we have a one-year disability rights fellowship, which is only open to students with a disability who are between 0 and 3 years out of law school. Dan Ross, our current fellow, is here today, I urge people to apply. We get extraordinary applications, and this year I had the repeated feeling that they should be interviewing me for why I should be there. So many extraordinarily accomplished young people who were applying for the fellowship. And I'm looking forward to talking to you about the National Conference of Bar Examiner cases and what they may mean for you and your applications to the bar. Thank you.
Well, thank you so much to the three of you. So we're going to have about 15 minutes for each of these topics. And I really like law school classes where people can be engaged. And so rather than having a formal question and answer session at the end, if it's okay with our panelists, if anybody has a question related to something they hear, chime in. And the only difficulty with having a legally blind moderator is I might not see you raise your hand. So just speak up, and we'll get you into the mix. But to go first to the LSAT case, this is an issue that for a few NALSWD conferences in a row we've talked about, and there may now be some progress with a recent resolution from the ABA. And I also mentioned to Beth that I would talk about a case that, as a public interest extern at Northwestern, I've worked on with a blind attorney in Michigan, in which we've sued the American Bar Association for their accreditation rules as they relate to the LSAT. So I'd love to hear each of our panelists talk about where their views are on the LSAT, where they think we've gone in the last couple of years, and what the trends are in that area. So whoever would like to lead it off first.
Karla does.
I do? Okay, fine. Sure. I have a couple things that I can say about the LSAT, and I guess I'll start from the specific and move to the broad, because I think the broad is more likely to provoke other comments and reactions. So on the specific, one of the things that I did when I worked at DRA in partnership with Dan and another attorney, Scott LaBar, was we sued the Law School Admissions Council not for an accommodations issue on the exam itself, but for their website not being accessible to people who use screen readers. And in addition to that, one of sort of is related to the LSAT. One of the things that they make available through their website and probably through other channels as well are test preparation materials. And they did not have test preparation materials in accessible format. So that was part of our suit as well, of our complaint, which we brought in California in state court. And after lots of back and forth, it sort of dragged out, and we wound up, and this is something that kind of plays into the lawsuit that Jason mentioned, is who are the parties that need to be involved. What we determined after a while is that LSAC would come back to us and say, well, we provide the application on our website as a convenience, but people can apply directly to the law schools. And so, it's really not up to us. If there are other means that people can apply without going through our website, which is actually not true in the case of most law schools. Most law schools do require you to go through the LSAC website, and even if they don't, there are huge economies of scale that going through the LSA website allows you to take advantage of. You just fill out one application, all of your letters of recommendation are processed through that. Any of your other supporting materials are processed centrally through the Credential Assembly Service. So to ask people to go through and do all of that independently for each school they apply to is a huge burden to impose on people simply because you have an inaccessible website. But to sort of, increase some points of leverage on LSAC, we decided to add several different law schools to our complaint. And we did that, and after doing that, eventually LSAC came to the table and decided to settle the case. And they've committed to improving the website as well as making test preparation materials available, more sample tests, more practice tests in more formats. So that was a nice victory. In terms on the accommodations front, I worked on a couple of sort of informal, not litigation, but sending letters and negotiating directly with LSAC on behalf of test takers with disabilities. And in two cases that I worked on, they were people who wanted to use screen access technology. They wanted to use JAWS or Kurzweil. So this is kind of a theme that you'll hear more about when Dan talks about the NCBE cases, is that that this is the technology that people are using in school. They're using it in their internships. They're using it on an everyday basis to deal with reading text and test-taking type of tasks. But LSAC would not, as a matter of course, allow people to use that on the LSAT. There's a little bit of a difference in terms of how LSAC has dealt with this issue than how NCBE has. They tend to be more ad hoc about it. They, have not, as far as I know, sort of come out and publicly announced or published a statement that they will never, under any circumstances, allow people to use JAWS or other, screen access technology. But in many, many cases, when people request that, they deny it. They deny the accommodation. They say, well, you haven't justified that it's necessary. You haven't provided enough documentation. And then they'll change their tune and allow it if the person either is very persistent and does provide a lot of documentation, or more often when the person gets a lawyer. And when they hear from a lawyer and they say, uh-oh, this is going to get dicey for us, it's not worth it, okay, we'll give in and let them use the technology. So it's sort of a more, they'll knock you down if they think they can get away with it type of approach, which is, in some senses, it's easier to overcome, because if you exert a little bit of pressure, they may fold, but it's also frustrating because they're a moving target. So we've succeeded on representing a couple of people to get the technology, but as far as I know these discussions are ongoing, haven't gotten them to commit to a whole-scale change of policy on that. So that's sort of taking me longer than I expected to say the two narrow things. So I don't want to spend too much time on the broader in terms of, the challenge to the test as a whole. I do have opinions on it, but maybe I'll let other people speak first, and I'll just chime in if I feel the need.
Paula, you want to talk about the ABA stuff?
You want to talk about litigation first?
Well, in the LSAC area, there's been relatively little litigation because, as Karla pointed out, as soon as either Joanne Simon or any of the lawyers who are expert at testing, as soon as their name surfaces on a letter, then all of a sudden the LSAT decides it can provide the requested accommodation after all. So they've taken much more of a rope-a-dope strategy, and been unwilling to be confrontational. Joanne sent to the Department of Justice a series of complaints against LSAC to try to empower DOJ to say there's a pattern in practice here and reach a broader settlement. That hasn't happened. There's been one settlement I've seen come out of those DOJ complaints. It was one where the testing entity was, LSAC was denying that the person had a disability. But by and large, there hasn't been a real opportunity to do something, and it's as you might imagine, not possible to do this on a class-wide basis. At least that's too strong. I haven't figured out a way to do it on a class-wide basis. There may well be a valid class-wide basis to do it. And maybe that's a segue into talking about what happened in New Orleans.
What happens in New Orleans stays in New Orleans, right? So no, in this case, not. So I'm a member of the American Bar Association's Commission on Disability Rights, which has had like fits and starts of activity and disactivity and effectiveness and ineffectiveness, but there's a new leader in place, and there's new both staffing and bar membership leadership who actually understands how the ABA works and how you get stuff done within the ABA, and there's a huge amount of energy. So it used to be you might have been embarrassed to say you were a member of the Commission on Disability Rights, like what do they do? But not anymore. Now it's like, oh my gosh, we kick ass. So we just, with Scott LeBar and with Dan Goldstein and real membership, grassroots membership, working the ABA, got a resolution passed from the American Bar Association that has since gone out to the LASC, Law School, whatever their acronyms are. And so all these people who test, all the testing people and all the people who are, deny first, then say yes, especially if you're one of 6 lawyers who writes a letter and then your client gets an accommodation. But for the rest of us who don't have either the money or the resources or the wherewithal or the knowledge that you can get to one of these people, the American Bar Association just sent a very, very strongly worded resolution that had over 35 co-sponsorships, like 7 former ABA presidents, no opposition from the floor, unanimous, that says, guess what, you guys who are being the gatekeepers to accommodations, that you have to follow the law. That is very clear that Title III of the Americans with Disabilities Act covers you as a testing entity, and that you are required on an individualized basis at least to provide accommodations for people who request them with disabilities. So it was a huge victory, and it was one of these, the last time the commission did a resolution was over 20 years ago. So it was like, it was good for the commission, it was good for the ABA. We all went and lobbied among the constituent groups to really raise awareness of the issues. The loss, I think they didn't oppose. People asked us to take the resolution off the ballot, like those were the law school professors for some reason. I have no idea why they would be opposed to accommodations for potential law students, but they asked us to take it off.
Legal ed also.
And what?
Both legal ed and ALS.
Right, legal education. And the judges were neutral on it. And I'm a member of the American Association of Law Schools. I'm a visiting associate professor of law at Loyola Law School in Los Angeles. And I actually I've presented twice now at the Clinical Education Conference on accommodating law students with disabilities in a clinical setting. So, I mean, I know it works. So it's just kind of, it was odd to me that they were so opposed to it. The next resolution that the ABA is taking on, the commission is doing, we're doing 2 things. One, we're actually making the ABA, we have actually are training the staff on their legal obligations to make the American Bar Association in line with the Americans with Disabilities Act, both their website, their programs, everything will have captioning now, and if it doesn't, you need to let me know. So there's lots of good things happening in terms of awareness of accommodations within the ABA itself. And we're doing a new resolution on people first language. One of the things that I think is really important about this meeting is that it's a cross-disability organization, NALSWD. You're not just dealing with people, you're not just saying, oh, it's all about me, and me has a vision impairment, or it's all about me, and me is deaf, or it's all about me, and I have a mobility impairment. It's about all of us together in this. And so I think it's a very, very powerful statement that you may not need a particular accommodation, but it's in everybody's interest not to discriminate against people with disabilities. And so that I would love to see, and I know you're in the process of getting a legal status, but I can't wait to see NALSWD as my client, as a plaintiff in one of these cases where we do challenge the LASC, because we need something, by the time, we need somebody who's going to be there for the long haul through the course of litigation. So somebody doesn't graduate or somebody doesn't get into school. And right now, somebody has standing, right? And we know actually right now there's a petition for cert pending from Ticketmaster out of a Ninth Circuit case about class representation and standing. Does each class rep need to have Article 3 standing? So I know that my office, we tend not to write amicus briefs at the petition for cert level because we think this isn't important enough for us to waste our time. Hint, hint, don't take this case. But if they do take the case, then we'll write an amicus brief on those kinds of issues. So the other thing that came out of the commission recently was a listserv for law school administrators. We had a meeting here in Washington, D.C. of all the regional law schools to talk about how are you doing accommodations for law students? What are your issues? Who do you talk to when you have a question so that you get the best possible outcome for your students to be successful? And we're piloting that in other cities. But what came out of it was a listserv so that you could talk with other deans who have that experience to really develop best practices. So if you're not on that, if you go to the ABA website, there is a place to sign up for this listserv.
In our remaining couple minutes in LSAT land, I wanted to come back to Karla because I know you had a couple general policy concerns and arguments about where the test is going generally. So I want to come back to you on that before we transition to talking about disclosure issues in employment.
Sure. Okay. Well, I'm going to comment on the Michigan case that you mentioned because I looked at it and I think it's an interesting issue. We probably don't have time to fully explore it, but I'll throw out my 2 cents and then people can come yell at me later at the reception if they want to, I guess. I think it's just to give background to people who don't know about the case that Jason was referring to. It was a case brought in federal court in Michigan by a visually impaired or blind man who was seeking to apply to law school and didn't get into some law schools because his LSAT score was low. And he brought the case against the ABA for requiring a standardized test as a component of the credentialing process for law schools to be credentialed and for their application. Doesn't have to be the LSAT, but it's sort of the preferred test for law schools to use. And the complaint alleges that because the logic game section of the LSAT involves spatial reasoning, and often people solve it by drawing diagrams, it's discriminatory against people who are blind or visually impaired. And by requiring it, or asking law schools to require it, the ABA is complicit in that discrimination. Jason asked me or all of us to take a look and sort of comment. I was aware of the case, but I hadn't read the pleadings until this week. So now that I've read them, I have two reactions. One on the law. I think the case has some problems on the law. Standing is an interesting issue as to, and I think they all sort of boil down to who's the proper defendant. Is the ABA really the proper defendant, or was LSAC the proper defendant? And I think on standing that presents a tough question because if the ABA no longer requires the LSAT, that doesn't mean that the law schools will stop requiring it. And so there's kind of an indirect piece there that is an extra burden for the plaintiff to prove. The piece that I'm more certain of, because I've briefed it and I've worked on it in the NCBE cases, is who offers the exam. Who is an offeror within the meaning of Title III, and there's a provision in the ADA that talks about offering an exam for professional or post-secondary purposes. And the ABA argued in its motion to dismiss, we don't offer this exam. We might endorse it. Well, they didn't say this. This is my gloss on what they say. We might endorse it. We might recommend that people use it or even require that they use it, but we don't provide it. We don't have any control over what it contains, over the formats in which it's given, over the accommodations that you can get. That's all up to LSAC. And having dealt with some of these same issues in the NCBE cases, I think the ABA has, let's put it this way, that there's a more of an uphill climb for the plaintiff here to say that the ABA offers this exam than there was to say that the NCB offers the exams that were at issue in those cases. There was more sort of factually linking the NCBE to those exams than there is linking the ABA to the LSAT. So those are my sort of concerns, or just doubts about how the case is going to go. But it sort of depends on the judge and whether they want to be very textual or whether they want to say, look, this is a broad remedial statute. The ABA has something to do with this exam. They're telling people to use it, so let's not knock it out at the motion to dismiss stage. Let's allow discovery and see where it goes. And I've certainly been wrong before about what judges are going to do. So anything could happen. And then the last thing I'll say is I think there are philosophical issues with the way the case is framed, and that before I had ever read it was my first reaction. It creates a tension, I think, to say that an exam is inherently discriminatory against a group of people because it might call for spatial reasoning or something like that, without saying anything about accommodations that can be offered on that exam to level the playing field. There's language in there about it disadvantages blind people. That I can probably agree with that, but to say blind people can't perform spatial reasoning or can't create diagrams, and there is some language like that. It's very broad language, and I think when people use broad language like that about what people with a certain disability can't do, it could have unintended consequences down the road if, depending on who reads that, who's aware of it, especially how it's portrayed in the press. When you come applying for a job someday and the employer is thinking about, what, we do cases that involve, evidence that is visual, or how are you going to deal with that? And I think, as people with disabilities, we just have to think and be careful about the messages that we're sending. And that's always been something that's kind of concerned me about this case and how it's sort of portrayed, particularly in the press. But that's all I'll say for now. We have other topics.
I'll just mention quickly the history of the LSAT is an interesting one. They reinvented themselves 5 times. There have been math components, then there have been no math components. There has been reading comprehension, there's been no reading comprehension. Literally, the test has been rewritten in terms of its emphasis and what it tests for 5 times since its inception. The one correlation you can make is that there's a 0.41% correlation with first-year grades, which I'm no statistician. That probably means you can account for 16% of first-year grades by the LSAT. So, and that 0.41 predictive number hasn't changed as it's reinvented itself each one of those 5 times. So it hasn't mattered what the content of the test has been in terms of its predictive ability. But nobody has apparently noticed the nudity of the emperor here and said anything about it. The other thing that I wanted to mention, Paula talked about the ABA resolution. Very important, the second provision of that resolution says that the LSAC should stop flagging accommodated results. And that is a truly wonderful thing. You know, the ABA the Department of Education delegates the ABA to the ABA, the accreditation of law schools. The accreditation standards say you can't admit students without a validated test. And the flagging statement is, we can't say this test is valid for this student, which means that in effect, every time a law school admits one of you, they're violating the accreditation standard. The whole point should be that the accommodation is designed to put a student with a disability on the same, I hate that it's trite, level playing field, but on the same basis as the student without the disability, in which case it is valid because you have 2 people competing on the same basis. And the LSAT folks just so resent having to get away from their standardization that this flagging is sort of the last sort of irritated slap at the student for deregularizing. You know, it's probably in their minds as big a sin as having the desk 35 3/4 inches away from the next desk instead of 36 3/4 inches away from the next desk. It's very tough on those control freaks when you all come along because you don't fit the norm. So I'm optimistic we're going to see flagging come to an end as a result of the resolution.
That's a great resolution, and I want to say as a moderator's prerogative for a minute, Karla and I may disagree substantively on the ABA case, but she did a great job of zooming us in on where the court's going to look at and making their decision. And it was a very interesting oral argument, and to hear this statutory interpretation, whether the court should take a textual look at it or not, that's exactly what the oral argument came down to. It was very interesting, and it'll be quite curious to see where the court goes on it, and hopefully we should know fairly soon. But I wanted with that transition to very quickly, before we get to the bar, to the NCBE cases, there was some interest in talking about disclosure in the employment context, and I think I'm going to go back to Karla because you had some points when we emailed back and forth about when to disclose, how to disclose, what to do if disclosing turns out to be a big mistake, and what if you get pushback, and how to approach that entire dynamic with employers.
Sure. Yeah, it's one of the trickiest issues, I think, to negotiate as a person with a disability. You know, not just a future lawyer. You know, in any type of job that you're going to be applying for, and it's very individualized. So you know, I'll sort of speak a little bit from my own perspective of what I've done, and then kind of what I've heard other people say in situations that differ from mine. But it's certainly not something that is one size fits all. It's the antithesis of that. But I think one of the factors, well, okay, so sort of going temporally, one of the places that you can disclose without officially disclosing, but just through context, is what's on your resume. And I would definitely say if you have a lot of leadership experience, if you're an officer in NALSWD, for example, or you've had a role in another identifiable disability group, my advice, or I think there's, for one thing, something very sad about sort of editing or censoring those things out of your resume because you're concerned about backlash from an employer because you're outing yourself as having a disability. Because that's part of who you are. That's valuable leadership experience, and I certainly would not advocate doing that. Unless maybe you have a million other things that you've done on your resume, and you have an excess, and so there's things you can cut. And then you can customize the resume if you want, in the way that I would definitely recommend, or at least what I've done is customize the cover letter. If I'm applying to a job, obviously I'm applying for Dan's firm's disability fellowship where I have to disclose in order to be a candidate, but most things are a little bit fall somewhere else on that spectrum if it's a disability rights organization that I'm applying to, or if it's a civil rights organization, but among other things they do disability work, or just from what I know about them, from other people that have worked there, I have a reason to think that knowing that I'm blind would be viewed as a positive, and that I can use that to explain why I care about these issues, then I would put that into my cover letter. Again, it's part of who I am. It's part of why I care about this work. It's part of my story. Leaving it out seems deceptive or not being true to myself. And it's advantageous for that particular job. If the job is not in the disability rights or civil rights arena, I don't have any particular reason to think it would be viewed positively. Then I wouldn't mention it in the cover letter. I haven't mentioned it in the cover letter. And what my approach has been about when to disclose is, as soon as I have an in-person interview, because I have a visible disability, I've disclosed. By showing up in the room for the interview, I've disclosed. And then I have to figure out how to bring up, if the employer isn't going to bring up what sort of accommodations do you need question, or how are you going to do the job? There's the questions that they're permitted to ask under the ABA and the EEOC regs, and then sometimes there's the questions that they're not allowed to ask that they ask anyway. But they may or may not ask even what sort of accommodations do you need, or how would you do X, Y, Z, questions that they're allowed to ask because they may not know to ask them. They may be afraid to ask them because they're not sure what the law is, or they're just uncomfortable. So I try to find ways during the interview to answer the question without them having asked it. So I'll be telling a story about what I did at my former position in my last job, and I will just give a little more detail about, I was doing a lot of research, which I do through using a screen reader, and this is how I do research. I'll just sort of volunteer, this is how I do X, because I assume that, or I could ask, have you ever worked with someone who uses a screen reader? And more than likely they'll say no if it isn't, an employer that has a lot of history in this area, and then I'll explain it to them. I bring my equipment to interviews so that I can do a little show and tell with them. Here's my laptop. Here's how the screen reader works. People tend to find that interesting if they haven't been exposed to it, and it breaks the ice and it normalizes it and shows them that it's not some huge, expensive, cumbersome piece of technology that's going to intrude in their office space.
Your scanner.
Yeah, I have a portable scanner, so I could theoretically bring that to an interview too, but I haven't in the past. But yeah, I just try to in context, mention what technology I use and how I do various things, and then that tends to free them, open them up to ask follow-up questions. So that's kind of what I've done. I have had a couple instances where all the interviewing has been done by phone, so that, de facto disclosure moment has never come up. And then, of course, for people who don't have visible disabilities, that isn't an option. So that's a trickier question as to what you do in those. Either you're never face-to-face, or you, by your very sort of presence and being there, isn't obvious that you have a disability. And I think in that instance, it's sort of my rule of thumb is it depends on what, if any, accommodations you plan to ask for once you start the job. If you have everything you need, and you're really not going to be asking for any accommodations beyond maybe just sort of minimal, like where your office is, to make sure it's in an accessible sort of part of the building, or something that is pretty minor in the scheme of things, then certainly regardless of what kind of accommodation you're asking for, you're within your legal rights not to do anything until you're hired and you start the job. But sort of my rule of thumb is, if you're going to be asking for some significant accommodations, just in terms of sort of human dynamics and knowing how they're going to react and whether they're going to be accommodating and whether you want to work with them. If they're going to have a problem with that and it's going to turn confrontational, you would like to know that sooner rather than later as well. So in that case, I would mention it, certainly not, by the way I'm going to ask for these accommodations, I would mention it in the way that sort of I've described before, kind of inserting it into conversation if it's a phone interview, or inserting it, if this is the work I've done before, because, I have such and such disability, and so, I use these accommodations to do my work, kind of working it into an answer to a question that's not about disability, but introducing it into the discussion so that they're aware, and then that can sort of lead to further discussion about the accommodations, if there are going to be accommodations that you're going to request. So that's...
Yeah, we're gonna. Right. I think we have a couple audience.
Right. So you asked. So you mentioned at some point that they do occasionally ask some impermissible questions, and how do you respond when someone asks one of those questions that they're not supposed to be asking?
Do you want the job? Yeah. So.
Yeah, exactly. I think Paula hit on it. If they've pissed you off to the point where you don't want their job anyway, then I would come right out and say, you can't ask that. That's inappropriate. You can cite the law if you happen to know it, or just say that that's inappropriate. If you want the job and you want to keep a good relationship with them, then answer it as best you can, or don't answer the exact question they asked. Answer what you think is appropriate to answer, and try to transition it into, and here's how I would do X, Y, Z. And then, maybe once you get the job and you get to know them better, then tell them what they did was wrong. But
the other thing you can do is you can go back. You can go back and say, "Are you asking me?" And then fill in the blank. So you're asking clarifying questions to try and get to the underlying concern that they have, because no one wants to have their hands smacked. As an interviewer, as an employer, we don't want to have our hands smacked. Even though I'm willing to say that to people, but I have a job, so it's very different. So if I'm applying for a job and they're asking me an inappropriate question, in the past I just try and address what their concern is. So, for example, I had a couple of years off. There's a gap in my resume. Someone interviewed me and said, "Well, there's a gap in your resume. Why? What does that mean?" It's like, who are you? And it's like, so are you concerned that I won't be able to meet the attendance requirements of the job? So I did take some personal time off there. I have 2 kids under the age of 4, and I took time off. So I was trying to understand what they were trying to get at without having to disclose more than I really wanted to tell them. And these were actually colleagues and people that I knew. And my first response had been, are you seriously asking me that question? And then they were like, yes, we want to know. And I said, well, there was, I was fortunate enough I was able to take some time off. In our situation where we are dealing with people who are have taken time off for chemo, and then there's inappropriate, there's questions on an application that says, have you been hospitalized in the last year? Well, you can't ask somebody that. And so what we say to our clients is, you can answer that you are ready, willing, and able to do the job, and you leave it at that. Recently on the DRBA, the Disability Rights, why am I bad at acronyms today? Bar Association listserv, a student applied for a job, used a professor as a reference, and the professor, when they spoke with the potential employer, referred the employer to the Disability Service Center to talk about the student's accommodations. Like, how wrong is that? That's like, what a violation of privacy rights, of everything. And so I think at that point, the law school professor needed to be educated. The Disability Service Center would have, if they were smart, will say, that's really not up to us to talk about. Those are private, privileged things. I can tell you that you can go back to the professor. And also what you get in law school, the accommodations that you get and need in law school, are not always the same accommodations that you get and need in the employment setting. And so, pardon me?
I'm sorry, I apologize.
No, so I mean, that was just horrific all around. So what is the perspective, what does the law student say? I think the law student says that you talk about what your skills are and what you bring to the job and how you value, and then I actually think it's really important to belong to organizations. And I really do believe it's important to have a mentor. And I really do believe it's important to practice those questions, because everybody asks illegal questions despite the law. The law gives you a really good reference point for making, to understand what our norms are, but it doesn't mean people are going to comply with them. They're more aspirational. And so I think it's, as all of us have been, have encountered those kinds of discriminatory questions in an economy where you really you want a job and you have a lot of debt and it matters to you to get the job, I think that you end up needing just to be more sophisticated than your employer. It doesn't mean, I worked for a horrible woman. She actually told me she owned me. She said, Paula, I own you. I went from doing hourly contract work to, I don't know how I end up with this, and this was a civil rights plaintiff's employment law firm, so hey. I went from doing contract hourly work to becoming a staff attorney, and she said, Paula, starting Monday, I own you. And she said this in the reception area in a room full of people, and a late Friday afternoon as I was walking out. And I was thinking, gee, 2 kids, my husband's not working, I'm the sole breadwinner. I get to say, goodbye, good riddance, or I don't, because I really need that job. So I turned around and I said, you know what? Slavery was abolished. I work for you, but you don't own me. And, because I knew if I didn't stand up to her, my life was going to be miserable, just miserable. But I certainly needed that job on Monday. And she backed off because she's a big bully, and I just didn't take it. But I was completely, taken aback, insulted, and, just did not want to go to work on Monday, but I wasn't going to let her win.
Is there another question? Can I ask Dan a question about the flagging process?
Yeah.
Practice. I was very glad to see the ABA resolution like you. And I'm taking a seminar on disability rights this semester. I raised the issue we were dealing with like an old law school admissions case. And I think the class split down 2 ways, which is one was what you said, which is this is a way to sort of wing things by the LSAC and say we can't really vouch for this store the way we vouch for other stores, and so a lot of us don't like that for that reason. Other people in the seminar said, you know what, it's a good thing for students with disabilities because all law schools want diversity, and that's a form of diversity, so flagging is good for you, so stop complaining. But I'm just wondering what your, I know what my reaction is to that, but I was curious.
I think that if you look at most law school statements about diversity, you will see the word disability missing from the list of gender, orientation, blah, 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 blah. If you look at most ABA statements about diversity, you will see a disability missing from that diversity statement. In fact, almost anywhere you turn where there's a statement of diversity, disability is absent from the list. And so what that tells me is that your law school students are ahead of the curve and may represent a more enlightened view for the next generation. But the folks that are making the decisions right now don't see disability as anything other than a factor in the group life insurance rates for the employees, how that's going to affect the disability insurance, and can that person really do this work? That's still the attitude.
And I'll just add real quickly to that. With everything that we kind of talked about, it's how you having the power to disclose and how you disclose if you choose to disclose. And if you're applying to law school and you want to write in your personal statement about having a disability and what you've done and how it's defined you and what you've overcome, that's great. That's your choice. When they flag your score, you've lost that. You've lost the choice. It's mandatory disclosure.
So we're going to go just a few minutes over, and you're going to all resent me because I'm eating into your break a little bit, but it's such an important update in this last year, and I want Dan to be able to talk about the NCBE case for a few minutes to wrap up the panel.
All right, so very quickly, sort of 2 pointers for you all. First of all, if you're going to be looking for more than time and a half on the NCBE, on the multi-state bar exam, you're going to be in for a fight. You're going to need to document that to a fare thee well. They just don't like to move beyond 1.5 time. The other thing is, if you want to use a screen reader for the multi-state bar exam or the multi-state professional responsibility exam, and you're not doing this in the Ninth Circuit, you will have to file suit and get a preliminary injunction in order to get screen reader software. Now, I'm hoping that there are some things that are going to change that. On March 26th, we have a hearing on the attorney's fees in the Enyart case. California state law, God bless it, allows for multipliers. And so a $2 million plus fee award might just slow the NCBE down on the scorched earth approach it takes. I think the last case we did, for those of you who don't know, what happened is we sued for Stephanie Enyart for her right to use screen access software. We established that the standard that the NCB must meet is not reasonable accommodation, but rather that it must administer the test so that the results reflect that which the test is designed to measure and not the test taker's disability. And the language of the regulation actually says that so as to best ensure that the results reflect. In other words, the single most likely to have the result reflect that which the test is intended to measure. That's been, the testing industry as a whole has been very upset that we established that, but it's in the reg. It's always been in the reg. There are Rehab Act regs that are similarly phrased for K-12 assessment testing, college admission testing, etc. For whatever reason, nobody's ever chosen to make an issue of them. I don't understand why, but we did get that established in the Ninth Circuit, and so now folks who do need screen access software. Right. The NCBE ridiculously filed a petition for cert in the case. Cert was denied, so we've established that in the Ninth Circuit. We brought a case in the DC Circuit for a blind law graduate from Pepperdine who had flunked the California bar without the screen reader software 4 times. Got a preliminary injunction from Judge Catelli here. She passed the bar. The NCB then dismissed its appeal. The technical matter wasn't moot because we posted a bond. We could have litigated over the bond, but they chose not to do that. And then we had a case in Vermont for a blind student who also has essentially what's a form of auditory dyslexia. So she uses both screen access software, but also the Kurzweil 3000 software, and got a preliminary injunction there. The Second Circuit, I'm predicting, is going to dismiss the appeal as moot, not the case, but the appeal is moot. So it remains to be seen. But there's no sign so far that the NCBE plans to relent on this issue. So if you are planning to use screen access software, either because you have a visual impairment or you're dyslexic, you're going to need to start planning now to be prepared to litigate that issue.
Or move to California.
Or move to California, right.
Or anywhere in the Ninth Circuit.
Yes, anywhere in the Ninth Circuit.
That's true.
But that's, I'd love to tell you more about the cases, but I want to get into the break. But it's been quite a ride. We've won everywhere except in Maryland, where we did not get a preliminary injunction for 3 students. But so far, the other 3 cases, and there was another one in the Ninth Circuit, so we're 4 for 5 on winning these cases to date.
Thank you so much, and hopefully during the break, if people have questions about that case, they can talk to you. And I want to thank all our panelists for a great discussion, and we'll take about a 15-minute break. Carla.
You know what? Somebody said the associate here, right? He said petition stage, didn't file, you did, and I couldn't see what the comment was, don't file the services. This is a general one. That's the time to file. That's the time to file. Not exactly file the services stage. Any Supreme Court petitioner will tell you time to file to get a case on the Supreme Court is the petition stage. No, you're right. If you're trying to push it the other way,
if you file opposing cert,
I meant on the, I've heard people in all areas of law say, well, if they take the case, we'll file and we'll point the case to the court. You want the case. You don't. Then be silent.
So I want to represent you.
I hope you don't mind that I went there. I know you said anyone else is going to
I don't think it's
If I were,
I think I just told you.
So I'm following that.
Well, I need to.
Or those who were there too. Yes, for at least two.
Conditions of disability require accommodation history, use of screen access software.
Saw the 70 degrees. Because they eat starve before I'm more confident.
So, let me give you my card.
I overstated. Not very good.
I'm happy to talk with you about
So you want to put in my short as I do. So I did not. So I mean, which state, which area?
California, Arizona.
And in that state, we need a litigation. You mean?
No, in the Ninth Circuit, we won the Ninth Circuit, so no litigation is required to take the California bar presumption in Arizona. But probably will have to sue if you don't get it. Yes. It's sad to say, right now it is. Well, we've tried to do this very quickly so that they don't delay people's career. When you're in your beginning of your third year, we all launch.
But we have not now, but we have.
So he goes to my school.
Yeah, we have. You mean usually most of them are doing that?
Well, I just believe there were that many. Some, not all banks use that software. Some may agree to use a reader or Please.
I think I'm going to go. We're going to go around.
Oh, so when you
I think you'll probably be all right, but if not, I'm just saying.
I was listening, I just I recently bar exam, and because it's not enough, I was timing,
There's then going out to get lawyers and trying to beat them up and do something short of having a suit. We'll offer you time.
Number of months when you're I was part-time. The number of months. Oh no, I mean married. Not just I just really yeah, that's like I read that before. Then you will find something.
I think I was subtly on the flat.
It's a good question. So I did fellowship. I applied this year. It's like
Oh, you can't have snacks?
Yes.
That's 3 years after you
Just 3 years now.
Oh, for 3 years? Well, that's good. But I'm like starting it. Try next year.
It's overwhelming.
Yeah.
I mean, it's just, at the end of the day, I feel so little confidence in the selection process.
pick up a bread. Then it's
I
not.
feel like you why can't you just say yes to everything?
Yeah, right. Yeah.
It's a process.
Carla, it's Rebecca again. I'm just saying happy birthday.
Oh, yeah.
How long have you been here today? No, I'm supposed to hang around, or I said I'd come around to the reception. So I should have something here about like the facilities, like neuro-based wireless, right? Oh, no, we're all one of the wireless. Oh, I'll go after her. Okay. Oh, great. Okay. I'm nice to meet you. Karla, yeah, I was well, last year was here. Was it? I don't know. Okay, yeah, which is where I was living at the time, but I was actually out of town that week. But I should have given a shout out when I talked about your case. I didn't know you were in the room. Were you over here?
What if we all do like introductions and then we all get a few minutes?
You got it. Yep.
So I'm thinking that why don't we all